permit at first affirming the right of Buganig to cut these trees down, and then immediately retracted that when the tribe reminded the state that it had this buffer zone. So the state, in essence, was in concurrence with this decision, although they largely sat the case out. And the tribe opinion is a fantastic read in terms of discussing the religious significance of the land and the area, and ultimately Roberta Buganig took, I think it was 40 acres of land, and clear-cut the whole thing and made herself rich and then split. So unfortunately, the land was still clear-cut regardless, but it was a fantastic affirmation of how tribal courts can deal with these kinds of issues. The next case is Snowden versus Saginaw Chippewa Indian Tribe, and this involves a disenrollment case here in the state of Michigan. I'm not trying to highlight the activities of an Indian tribe that was engaged in what we call disenrollment of tribal members, which sort of has a dirty tinge to it now. But I want to point out that this is a fantastic an opinion written by Frank Pomersheim, who was an appellate judge for the Saginaw Chippewa tribe at that time, and Mike Witowski was also in that court as well, about the political theory of the tribal constitution. He brought in the history of the tribe, how they had been sort of coerced into this tribal constitution and coerced into these membership criteria that were the subject of difficulty for the tribal community in the modern era, and also is a fantastic discussion and discussion about what tribal constitutions are. So, like the federal government or the federal constitution, some tribal constitutions are of limited authority, in that only what's delegated to the government is actually available, and the rest is retained by the people. This is the kind of constitution that the Saginaw Chippewas had adopted. The other kind is a plenary powers constitution, which many tribes have adopted, in which the tribal government maybe has a list of things they can do, but they also have broader powers in accordance with the constitution that allows them what we call plenary powers to do what they need to do. This was not the kind of constitution that Saginaw Chippewa had, although the tribe had argued it was. The next opinion is what is typically called In Re Bakavi certified question, and it's about the authority at Hopi. And I love teaching this class from both my federal Indian law and my tribal law classes. I love teaching this case because in virtually any Hopi case, because Hopi has a very sophisticated structure of federalism. Hopi is not a unified tribe. They are not a unified tribe. There's at least there's more than 10 villages, all of which are functionally independent in many ways before they became put under the umbrella of this Hopi tribe, which is sort of a federal government by the United States during the IRA era. And the authority of the individual villages, some of which don't even speak the same language, is always in question by the federal government. There's this dispute, and in many ways it's a conflict like you would see in the United States with the feds over the states, that say in the healthcare context or other contexts. It's a beautifully rendered opinion. Ironically, there are actually two opinions by two separate courts, the exact same court, but by two groups of judges. An initial opinion affirmed the right of the federal government, reading the Constitution, the federal government this time being the Hopi tribe, to remove members of the tribal council who are elected through the various villages. And then that was a draft opinion. That court's term ended, and a new court came in and essentially reversed them. And it's fantastic reading altogether. The next case is another Frank Pomersheim case, which I think is absolutely important, called Plains Commerce Bank, and back then known as the Bank of Hovind versus Long Family Land and Cattle Company. We know this as a Supreme Court opinion in which the Supreme Court once again rejected tribal court authority. It's a fantastic opinion if you read Judge Pomersheim's opinion, because the tribal court opinion is much more broader in terms of what it's covering than the Supreme Court decision. The Supreme Court decision was on one narrow cause of action, ultimately that really decided very little, and much of it had to be remanded to tribal court for adjudication. The next case is a little bit older case than the rest of these, the Chilkat Indian Village IRA versus Johnson case, which is a great tribal court opinion in which the tribe adjudicates the question of cultural property. Some tribal members had actually attempted to remove cultural property and sell it to a guy named Johnson, who was a Seattle-based, sort of an Indiana Jones guy, except he wasn't selling it to museums, he was selling it for personal profit. And the tribe was bringing it back and had a wonderful rendition of what tribal property means, what tribal cultural property means. The next case, Sanowski versus Grand Ronde Confederated Tribes, is a due process case that arose in the context of an administrative employment action in which individual employees of the tribe had been terminated or disciplined in some way, and went to an administrative appeals tribunal before it would go to tribal court. And the tribal court case had to review whether or not the appeals tribunal, the administrative action, was in conformance with the Indian Civil Rights Act and due process clause. And ironically, Grand Ronde, and I think I've worked with tribes like Grand Ronde, Grand Traverse Band has gone through the same thing, that goes back and forth on whether or not in the administrative process to allow for the parties to be represented by an attorney. Most of the time, if the party is going to be represented by the tribal attorney's office, if the tribal government is represented by the tribal attorney's office, the terminated employee is rarely represented by anyone, and the fairness issues are very apparent. So the tribal council may order, and then this is what happened in this case, the tribal government to cease representing the tribal attorney's office, to cease representing the tribal government, so that all the parties are not represented by council. And what happened in Sanowski was a huge mishmash of confusion and basically a hatchet job in the Administrative Appeals Board. So the tribal court said, you got to have attorneys there, even if it's not fair to the plaintiff, the employee. You still have to, they can at least have a right to bring an attorney in. And the last case I want to highlight is Navajo Nation versus Rodriguez. This is where the Navajo Nation was confronted with the question of whether or not to adopt the Miranda rights. And it seems kind of obvious. For many tribes, they have sophisticated, modern tribal police forces. But the interesting thing, and so it would seem that you would want something like the Miranda rights. You want to be able to ensure that tribal members and others who are under the jurisdiction of, or being subjected to the criminal procedure activities of tribal police should be given their Miranda warnings. And that's very important. It seems obvious, but the Navajo Nation the Navajo Nation Supreme Court engaged in a really excellent analysis of what Miranda versus Arizona is all about. If you go back and read Miranda versus Arizona, you'll see that Chief Justice Warren's opinion is one of custom and tradition. We see a lot of that in tribal courts a little bit. We don't see it too much in the Supreme Court. And Chief Justice Warren wrote that the custom and tradition of the United States and the Anglo-American legal and criminal justice system going all the way back hundreds of years was one of grabbing someone you think is guilty, beating a confession out of them or coercing a confession, sometimes using rubber hoses and other kinds of torture, and then prosecuting the person and throwing away the key. The Miranda warnings were an effort to stop that tradition. We no longer wanted to have a tradition of the police beating people to coerce a confession. So the Navajo Supreme Court says, why would we adopt Miranda? The Navajo Police Department doesn't have, or excuse me, not the police department, but the Navajo Nation does not have a tradition of coercing confessions out of Indian people once they've committed a crime. At Navajo, and I think this is true in a lot of places in Indian country, the first thing that happens is the confession. In a small insular community, if somebody commits a crime, almost immediately the defendant actually confesses. And actually you see this continue even to this day in federal prosecutions, where when Indians are prosecuted in federal court under the Major Crimes Act, the conviction rate is well over 99%, in part because the first thing that Indians do frequently is to confess. And so Navajo said, why do we need to have the Miranda warnings? And they analyzed it and concluded that it may have been true under our custom and tradition, or at least Navajo's custom and tradition, not to coerce a confession, but it was also true that the Navajo Nation had adopted Anglo-style law enforcement capabilities and was engaged in that and trained in the way that the modern American police department was engaged in. They didn't coerce confessions, but they certainly would sit in the back seat with a defendant or a suspect and talk to them until they might have confessed or something to that effect. And so the Navajo Nation adopted the Miranda warnings and also added a little wrinkle in that when they do give the Miranda warnings, they have to do so both in English and in the language of the Navajo Dene. So I want to conclude. I went a little bit more time than I thought I would, but I want to say that it was a joy to speak with you and give you the opportunity to hear some of my thoughts, I suppose. I really hope that you could take a look at Indian Courts in the future sometime. If you get a chance to get a hot copy of it, it's getting kind of rare. And hopefully I will try to write up some of these comments that I've made and post them on Turtle Talk and maybe publish them. What I do plan to do for certain is post later today, and this for you would be Wednesday, PDFs of all of the tribal court cases I've talked about today. Hopefully you get a chance to look at them. I think all of them are actually in my, my case book, at least excerpted, but I will put the original PDFs as I find them and put them on Turtle Talk. And you can email me with any kind of questions you have. I understand there's going to be a panel after this talk, and I hope that it goes well. And I want to say thank you very much, Chimiigwech, to all of you for giving me the chance to do this, and I hope the rest of your conference goes well. Thank you.